to today's session. The topic of today's session is Facebook JIO deal, and it is golden opportunity for all of us to have Professor Rahul Singh to discuss this topic. Sir is Associate Professor at NLSIU Bangalore. He has completed his LLM from Harvard Law School. He was accorded with the role of visiting faculty at NLSIU at the age of 25 years, and he teaches regulate several universities, including
Yeah,
I
Astad,
guess that
thank you
this,
for that kind introduction. Sorry, Sakshi, go on.
no, so I guess there was some problem with Asta's audio. So it would be a pleasure if you start the discussion.
Sure. Thank you very much. Good afternoon, everybody. I'm delighted to be here. So the topic for discussion here is Facebook and Geo deal, right? So this is what we're going to discuss. So I'm not sure how many participants are around, how active we all can be, but there are a couple of things which I'll request all of you to do, which is, of course, you might have seen the CCI's approval order in terms of looking at the Facebook and Geo transaction, right? Even if you have not had the opportunity to look at this particular approval order, there are a couple of things that we need to keep in mind while we are looking at this transaction. And I'll only look at the competition aspect of this transaction, not the non-competition aspects. So to begin very quickly over here, I mean, you will see the date of commission's order is 24th of June 2020, but uploaded on the commission website very recently, right? So which is only last week or so. So in that sense, the commission, although it approved the transaction way back in June, there is a time lag in terms of uploading the approval order in public domain. But nevertheless, now we know what really went on in the commission's mind in terms of looking at this particular transaction. Right? Now, there are certain basic stuff that we need to understand before we can appreciate what is it that the competition commission is supposed to look at while they are reviewing a transaction such as Facebook and Geo. Right? So one aspect that we need to understand is that there is Competition Act 2002. In terms of Competition Act, there is this institution called the Competition Commission of India. For some of you, it might be very basic stuff, but for others who are joining in and might not have any background in Competition Act, I thought it might be a good idea to give a quick overview, right, in terms of what the act is, what is it that the commission is supposed to do, right? So in terms of the Competition Act 2002, there are these legal fiction called combination, and these combinations are supposed to be reportable to the Competition Commission of India, ex ante that is. And what does ex ante mean? Essentially, before the fact, which means that, even before a transaction can take effect, even before a transaction is consummated, right? The parties need to go to the Competition Commission of India and ensure that, the commission approves of this particular transaction. Now, that will happen only if, a transaction is a combination within the meaning of Competition Act 2002. Now, if you're somebody who is very statute minded, it would mean that you go to the Competition Act 2002, read section 5 of the act, And along with Section 5 of the Act, you should also read Section 6 of the enactment to figure out whether a particular transaction is a combination or not. Right? An equivalent sort of terminology, if you are somebody who is quite minded in terms of looking at things comparatively, an equivalent terminology in the EU or the European Commission context would be concentration. Right? So in the Indian enactment uses the term combination, and it's there in Section 5 and 6 of the Competition Act. What makes a transaction a combination? Well, essentially the test is based upon a size of person right now. And when we say size of the person, it would mean both the acquirer and the target. In our case, for instance, this Facebook and JIO, it would mean that you look at the assets and turnover of Facebook as well as JIO, right? And that would mean that the size of person test as the commission is supposed to employ, whether that is being breached or not, right? So that is just very basic stuff in terms of looking at what a combination is. You will also notice that if you are somebody who has read the CCI decision, that the commission itself does not explain to us how and why they thought that this particular transaction is a combination. Again, as a quick comparison, if you are somebody who is looking at, let's say, the EU competition law, and if you read, let's say, what the EU judgments look like, they will, at the beginning of the judgment, tell you how a particular transaction is a concentration before proceeding to give you their standard of review. Now, with that, let's move on to another basic stuff, which is, at this stage, in terms of Indian merger review, Indian competition law, there is no size of person test. Sorry, there is no size of transaction test. We have already seen a size of person test, but there is no size of transaction test in the sense that what it means is that we don't necessarily have to worry about the quantum of consideration that passed between two parties, right? So that's not something which is supposed to make any difference to the Competition Commission's analysis with respect to reportability of a transaction, right? Now, this is another basic stuff which is important only because there is a pending proposal. There is a lot of talk in public domain that they want to introduce a size of transaction test as well. But at least at this stage, the law does not have the test, and therefore we don't need to worry about it. Why is it critical that in a transaction like Facebook and JIO, why should we talk about size of transaction test? Well, it's important only because at least in the digital economy segment, there are a lot of people who believe that there are several transactions which escape the radar, so as to speak, of the Competition Commission, merely because the size of the parties may not be very large, right? And also because, at least in Indian competition law, there is a de minimis exemption which is based upon the size of the target entity. And therefore, in the digital economy context, where size of the target may not be, at least in terms of assets and turnover, may not be very large, there is this fear that many of these transactions, which otherwise should have been reported to the CCI, might not have been reported. Only because of that background, it's important for us to understand that there is no size of transaction test as of now, and it's a proposal which is pending. Now, with that basic background, let me move on to what is it that the commission is supposed to do once the transaction is reported to it, right? So the way it goes is, one is, we have already seen, it's an ex ante requirement, which basically means, in simple English, it would mean before the fact, right? So even before a transaction takes effect, you should, or you must, in fact, go to the Competition Commission and take their approval. So in that sense, it's ex ante, and if you already consummate your transaction, then there is a risk, twofold risk. The commission might unravel the transaction. There might also be penalties which are imposed. So I'll not get into the penalties yet, only because the kind of decision or the transaction we have in mind today, the commission has given approval, so the question of penalty does not arise, right? In any case, the other aspect which is relevant for us to appreciate is that once a transaction is reported to the Competition Commission, what is it that the commission is supposed to do, right? So essentially, what we should try and understand is what is the standard of review that the commission employs, right? Now, so this standard of review, by the way, you will see in the Act itself, which is there in Section 20, Clause 4 of the Competition Act. So it is supposed to, in sum and substance, because there are several factors over there. What the commission is supposed to look at is what is the quality of uh, impact of this particular transaction on competition. Or in other words, the shorthand here would be appreciable adverse effect on competition. But what does that really mean for the commission to appreciate and understand or take a view on whether there is appreciable adverse effect on competition or not? So several factors. For instance, it will start with, is there, let's say, competition from exports or imports? Are there sufficient number of players in the market? What is the entry barrier in this particular segment? And of course, so let me take a pause at this entry barrier bit, because if you had a chance to look at this Facebook and JIO case, you would see a lot of analysis which the commission devotes is upon this idea of barriers to entry, right? Whether because of this particular transaction, does the commission believe that the quality of competition in this particular segment, and I'm not using any of the technical jargons yet, which is when I say this particular segment, the technical jargon would be relevant market and stuff like that. But in order to just make sure that people who are not initiated yet in the competition jurisprudence, they may also be on the same page. At this stage, I'm deliberately trying to avoid using the jargons, and as I lay down the basic background, I will move on to using the jargons as well. Right? So at this stage, so as a shorthand, we'll say that the standard of review which the commission is supposed to employ is that of this appreciable adverse effect on competition. What can be shortened as AAEC, or maybe even ACE, which could be considered as anti-competitive effects, right? Essentially, the idea is two parties are coming together. What could be possibly an anti-competition effects, ACE, what I'll say in a very short form. Although the enactment uses AAEC, by the way, appreciable adverse effect on competition. One doesn't need to get lost in these terms, only because I'll tell you why. Because you see, these terms and terminologies based upon jurisdictions, they differ, right? So for instance, if you're in the US, they'll say, is there a substantial lessening of competition, right? Or if you're in the EU context, they'll say, is there a significant impediment to effective competition or not, right? So in that sense, if you are just using these jargons like AEC based on jurisdictions, it might just change. It might become SLC, it might become SIEC. In Indian context, it's AAEC. And therefore, one doesn't necessarily need to get lost in these terminologies, is my point. Therefore, I'll say as a short form, I'll just say anti-competitive or anti-competition effects, which is ACE. It doesn't matter which jurisdiction we are looking at, what are the anti-competition effects, right? So based on that, so we will at this stage, if I can summarize, there are only two things which I have mentioned as a background, that certain transactions which could be considered as combinations, they require prior reporting to the Competition Commission of India, right? Now, what are these transactions which are combinations which do require notification or reporting? They are based upon a size of the acquirer plus the size of the target test. We can assume that in this, Facebook and JIO transaction, that was satisfied, because as you know, these entities are fairly large in terms of their assets, in terms of their turnover. So I'm sure there is no risk in order to just assume that they are a combination, right? So it's obvious that probably they did require notification, and therefore they went to CCI. Only added probably because we don't have any insight from the commission's public domain decision as to how exactly the commission went about looking at whether they are combination or not. The only other thing which I mentioned as a very brief sort of introduction is to look at the standard of review, and I'm saying we should think about ACE test, which is anti-competition effects, right, or anti-competitive effects, right? So therefore, the question is essentially, for any particular transaction, if the Competition Commission is supposed to look at anti-competitive effects, what does it really mean in practice in a particular transaction, right? So that's all we will do for the rest of this presentation. So we started at 4 o'clock, it's 4:15. You see, I've quickly utilized 15 minutes to lay down very basic background on what we are supposed to do. so that even people who are uninitiated in competition law, they can appreciate what we are trying to do over here, right? That was the only idea. If you are somebody who is already quite sophisticated in competition law field, then due apologies, pardon me, I'll move on. But with this background, let's actually look at this Facebook and JIO transaction. So what will we do for this particular transaction? We'll do essentially two things. One is to look at what is it that the commission did in this particular case, which is just a descriptive sort of analysis, right? So we will take you through this order and look at what is it that the commission has done while they analyzed Facebook and JIO transaction. The other thing that we will do is to look at the commission's assessment slightly normatively, in the sense, is the commission doing what it is supposed to do in terms of that? So only two things I'll do for the rest of the presentation, and I'm not sure whether we can also have some questions and all here, but I mean, I can see there is some chat window which is available, but if you have any questions and stuff, please feel free to ask. If some of you are joining in or you have joined in through the stream yard, I suppose you can also utilize the platform and ask your questions. Questions are welcome at any point of time. I'm just laying down the background with the basic idea of what a competition law analysis looks like at the Competition Commission. Now I'm only saying that we will do two things on the Facebook and JIO transaction. One is look at the CCI order descriptively. What has it done, right? And the second thing is to look at it maybe normatively and see whether it has discharged its duty, which is laid down in the Competition Act. Now, these are the only two things that we will do, and let's actually begin, right? So you'll see one thing that is quite stark in this decision, by the way, as you will begin reading, is that, the title only says that, the notice was reported by this entity called JADU Holdings LLC, right? So the name of the entity is JADU Holdings LLC. Of course, the way it is spelled is JAADHU, which of course, I suppose in Indian context might also lead to a little bit of double entendre, so as to speak, right? Which is, do they mean Jadu as in magic, or do they mean Jhadu as in broom, right? So, which is what I'll use as sort of a, by the way, sort of a backstop for my own presentation. What does this transaction really deal with? Is it about some kind of a magic which is going to happen? Is that what they're concerned about? Or are they concerned about a broom, right? And why is it that these two allegories could possibly be significant from competition law perspective? Well, in either case, let's say if the transaction is too successful, magical, would it mean that competitors are somehow thrown out of the competition landscape? And let's assume that it will be a highly successful transaction. Why shouldn't we, right? It should be a highly successful transaction. Now, merely because, let's say, other competitors are thrown out of the competition landscape, is that infringement of Competition Act? Well, so, I mean, short answer here, no, right? So just because, some competitors are, for instance, getting edged out because, let's say, a particular entity is very efficient, right? It does not necessarily mean that it infringes Competition Act. So if it's a magical transaction, which is if Jadu translates to magic, doesn't look like there is much of a competition concern over here, right? But if Jadu is not Jadu, but Jadu is in fact Jhadu, which is, broom, I suppose, it could possibly mean that there are barriers to entry and exit, and that could possibly lead to some kind of what I had laid down as a standard earlier, which is the ACE test, which is anti-competitive or anti-competitive effects test, right? So there could possibly be, if the transaction turns out to be a broom, then it could possibly be a competition concern. So let me actually, just reiterate that we are looking at, this particular transaction from CCI's perspective, but we are trying to see whether is it a magical transaction or is it some kind of a broom-based transaction, right? So, and if it is magical, by which we mean that, if it is so successful that others are not able to compete, it is not really an anti-competitive effect. Just to give you a very short sort of an example over here, right? Many of you would remember, of course, deliberately taking recent examples because I'm not sure about the demography of people who are joining in today. But you see, you would remember the time when, let's say, in terms of cab and stuff, private cabs were ruling the roost, whether it was Meru cabs or mega cabs or any other cabs dependent on which cities you are in. I understand, some of the students might still be based out of Lucknow, though I'm sure that because of pandemic, many of you might have gone home. But I don't know what is the cab which is prevalent in Lucknow, and therefore I'm just using this as a sort of a rule of thumb, shorthand example. But regardless of whatever cabs might be, in vogue in Lucknow, the point I'm trying to make is that there was a time when Uber and Ola were not really that prevalent, right? Just few years ago, right? And then Uber and Ola came about, and then these other entities which were pre-existing from earlier days, whether Meru or Mega or any of these local cab agencies, they sort of found it difficult to survive, right? And therefore, in that sense, you can see that if the transaction between Facebook and JIO, if it's a magical transaction, by which I just mean that, if it's such a successful transaction that they turn out to be very efficient, and therefore other competitors are not able to, they're not in a position to compete with Facebook and JIO, then that's not really an anti-competitive effect. And that's not something which should be the concern of the CCI, right? On the other hand, if it turns out to be a transaction which just creates, barriers to entry for newer entities, or let's say barriers to exit, then it could possibly be some kind of a concern, right? Now, is this something which is there in the Act itself? Yes, in Section 20, Clause 4, you will see that one of these factors which is mentioned is about the quality of competition which exists, the concentration in the market that they are talking about. What does it mean? When statute talks about concentration in the market, the Competition Commission is a specialized body. It is supposed to have expertise in not just the law aspects of competition, but also economics, or the interdisciplinary methodology of law and economics. So it is supposed to be a body which will have that requisite interdisciplinary expertise in both law and economics of competition aspect, and it is supposed to analyze these transactions based upon a standard which is interdisciplinary, right? It's not just about what the statute says. So you'll see our analysis, what we are talking about right now, in terms of barrier to entry, it would be a law and economics based analysis. So that's what I'm trying to allude towards, right? Now with that, so I don't see any questions, which also means that I don't have a sense of how many people are participating, and whether people are participating at all or not. But nevertheless, let's move on. You will see very basic idea in terms of the order. You will see what is happening is this entity called JADU Holdings LLC is a US based entity, right? And the LLC just stands for Limited Liability Company, right? If you read this order, you will also see they describe that JADU was incorporated in March 2020 under the laws of state of Delaware, right? US based entity, not engaged in any business in India until now, but through JIO platforms wants to enter India, right? What are they buying? They're just buying 9.99% of the equity share capital in this corporate entity called JIO Platforms Limited, right? So in terms of the Companies Act, it's a corporate entity or a company, right? Now, JIO Platforms Limited is a subsidiary of Reliance Industries Limited. Again, another corporate entity. I'm sure all of you are familiar. One of the highly successful Indian corporate entity, has been around for a while, has done particularly well in last few months, right? And therefore, so this transaction is concerned about two of these entities. One is based in the US context. This ultimate parent entity, of course, is Facebook Inc., as it says, US based entity. The entity which is buying a certain shareholding percentage, which is 9.99%, less than 10%. So certainly a minority interest, which Facebook Inc. is indirectly purchasing in JIO Platforms Limited, right? So this JADU Holdings Limited, which is an indirect, wholly owned subsidiary of Facebook, is buying 9.99% of equity share capital in JIO Platforms Limited. So in that sense, the acquirer here is, the ultimate parent entity, of course, as an acquirer is Facebook, but the acquiring entity is JADU Holdings LLC, and the target entity is JIO Platforms Limited, right? Now, along with this particular transaction, which is just, purchase of this minority stakeholding, what is happening is that simultaneously there are these investment agreements and a master service agreement which is being entered into by other entities. Now, which are these other entities? So Reliance Industries Limited, JIO Platforms, JADU, and Facebook, they enter into an investment agreement. And what happens is that, as you would know, many of you, WhatsApp, which is another subsidiary of Facebook. So WhatsApp and JIO Platforms and Reliance Retail Limited, they enter into a master services agreement. Right? So you'll see many of these transactions in practice could be quite complicated, right? Because you're not just looking at what the CCI leg of a particular transaction is. You also have to look at, what is the investment agreements that we need to enter into. You might also have to be aware or familiar with what is the master services agreement that we need to enter into. So, life of a transaction lawyer could be quite complex in that sense. You have to keep your eyes on a lot of these moving parts, right? The competition approval is just one leg of the transaction. It's important to appreciate that, it's just one leg because, there are these so many other agreements which will give you the perspective in terms of what's happening on the investment front or in the corporate entities front, right? What we are concerned about today is only the competition aspect, right? So as the order progresses, what are they concerned about? So you will see the way it has been, written at least, and the way possibly, and much of these writing is taken from the way parties file the notification with the commission. But in public domain, what you see is that the concern is about, is there any kind of a horizontal overlap between the acquirer and the target, right? Now, when they say horizontal overlap, what does it mean essentially, right? Well, so essentially they are thinking of, well, when you look at an entity like Facebook and when you look at an entity like JIO Platforms, are there similarities between the two, right? Do they overlap in any particular segment? In other words, do they compete with each other, right? Even more, if you want to simplify it even further, by the way, effectively what the question of overlap is there a single relevant market here or are there multiple markets, right? Essentially, are they competitors, right? Now, how do we figure it out? By the way, are two entities competing with each other or not? I mean, is there a way to mathematically figure it out that two entities compete with each other or not? For instance, one can think of, let's say, in other particular contexts. If somebody has to ask today, let's say, because we are on this stream platform, right? If I ask you a question, what are the competing, let's say, platforms on the basis of which, let's say, one can engage in a distance-based learning today, right? So one can think of so many of them, from MS Teams to Zoom to Google Meet to WebEx to all of these, right? That's because they are interchangeable in the sense that, they compete with each other. They are part of the same relevant market. Okay, so I got a message that there is a question, so I'm just going to look at this. So yes, so there is a question from Khushbu Bapna. So how are the pro-competitive and anti-competitive effects under Section 20 Clause 4 compared against each other in deals like this? Are there certain rules and guidelines followed by the CCI? This is the question that has been asked. So we'll once we look at this horizontal overlap, we will look at the idea of this pro-competitive and anti-competitive factors as well.
Excuse me, sir. Sir, you're muted from your side. We couldn't hear you now.
Okay, sorry, I don't know how the muting happened on its own. I think when I went to the chat, it sort of muted me on its own. So I
Yes.
was just taking each of these questions one by one. So let
Oh,
me address the question on master services agreement bit first.
yes,
Okay.
sir, sure.
And now, if there are any questions, I'll just request you to, just speak it out for me, because I think the moment I am moving on to the chat window, it just mutes me. So, all right.
So
But anyway, let me. Sorry. Okay.
we could take the question at the end of the session altogether. If
Yeah. Okay. That works too. No problem. But let me
sure.
address the master services agreement bit, which somebody
Yes,
has
sir.
asked a question, because that I think is important. So this, I was just saying, from reading from the order, you can see what is possibly the meaning of master services agreement, because you can also see who is entering into master services agreement, right? So you see WhatsApp is entering into a master services agreement with Jio platforms and Reliance Retail. And if you look at the order closely, what are they trying to say? That if you want to fulfill an e-commerce order today, what is it that you do? I mean, mostly I suppose people in the pandemic world, they are going on to these apps, right? Whether it is Big Basket or Amazon, or maybe even locally, I suppose Swiggy, Zomato, all of these, they have all ramped up their deliveries in order to enable an online e-commerce, right? What is not happening, that local, let's say those kirana stores, the mom and pop stores which used to do business, you would have seen Mr. Biani's interview actually just few days ago. Somebody asked him, why is it that you had to sell off your future retail? And he said, the kind of loss that he suffered during the pandemic, he said it just made business sense to exit the market, right? So in that sense, I'm just saying, put all of this together, you can see what is the meaning of master services agreement, right? What is it that WhatsApp will be able to provide? Some kind of an access to people, right? Consumers, so as to speak, right? What is it that Reliance Retail will be able to provide? A network of, let's say, these mom and pop stores, these retail stores, which are in a position to service these customers, right? So you can see what possibly master services agreement could mean. Though, I mean, I say that with little bit of hesitation, only because towards the end of the order, you will also see that Commission has asked for an undertaking from the entities here, saying that the data sharing is not something which is the rationale behind the transaction, right? So they have sort of, the commission has, towards the end of the order, said, they have asked the entities, are you going to share data between each other, and is this why, because of which you are entering into this transaction? And there seems to be some kind of an undertaking suggesting that no, that's not the rationale behind the transaction, and therefore one shouldn't really worry about it, right? Maybe, because there was one other question about how does the commission balance pro-competitive effect with anti-competitive effect. Maybe one can also see this as an example. Of course, we can look at this later as well, but one can see this as an example of how exactly the commission goes about balancing, right? Because if there is a concern that is this because there will be some kind of a data sharing which will take place. So the commission can ask them this question, right? Which is, the concern is data sharing, and therefore, which so commission, if it is concerned about it, can ask the entities, and if the entities think that this is not something which is rational. For instance, in the order, you will see para 53. You will see it says, in the instant matter, it is noted that proposed combination is an acquisition of 9.9% stake in Geo platforms, and just the next sentence, it says, Jadu has submitted that there is no data to be shared as part of the proposed transaction. So maybe this is also an answer to your question, which is that, how does the commission balances these pro-competitive effects with anti-competitive effects? So they're asking the parties directly, are you going to share data, right? But even if there is no data sharing which is going to happen because of this master services agreement, there are certainly certain services that they will render to each other, right? Which is that, what could be those services, by the way? All entities exist because they are productive and they need to be profitable, right? And therefore, when we say that certain services will be rendered by these entities, one could mean that let's say, what could be a service which WhatsApp will be able to provide to Reliance Retail, right? It could mean that connecting a consumer to a neighborhood kirana stores, for instance, right? It's not about data, right? It's about the fact that you are a consumer sitting in, let's say, one part of the country. What are the nearby kirana stores which are selling stuff? And this is not just WhatsApp doing it today, right? If you use any of these other, let's say, competing entities, like, let's say, if you are utilizing let's say Swiggy or Zomato and all, right? Or maybe Dunzo, for instance, right? Because Dunzo is another entity which sometimes doesn't get adequate attention, but quite an interesting entity, right? Which is, you can essentially use Dunzo to get anything from anywhere, right? Not just your grocery items, but also maybe other items that you may want to transport, right? So therefore, something similar is, I suppose, one can think of as a what could possibly be the domain of master services agreement, with the caveat that I'm making that very clear. I've not seen the master services agreement. I'm just inferring this based upon what the CCI order is available in public domain is, right? Okay, so with that, let's move on. So I was on the relevant market bit, right? And I was on the overlap bit. So I was trying to ask you a question in order to ensure that all of you appreciate the point related to overlap and relevant market. So I was saying, if you think about the streaming market, so we are on StreamYard, right? But competing entities could be Zoom or Google Meet or MS Teams or maybe WebEx, right? So all of these entities would be horizontally situated. What do we mean by horizontally situated? Well, as a rule of thumb, as behavioral economists would say, heuristics, right? Heuristics as a rule of thumb. If there is a single market that we have to think about, like if we are thinking about just one market in which all of these entities are there, it would mean that there is an overlap and they compete with each other, right? But if we have to think about several, let's say, markets, then the overlap or the chances of overlap is very small. So if you see in this Facebook and JIO transaction, what is the relevant market that they are concerned about, right? So if you see, the first one that they think about is this consumer communication applications, right? So you can see where this is coming from, right? Which is one is, so you can think of WhatsApp as a consumer communication application. Sorry, this went on. So WhatsApp is a consumer communication application, right? And then you can also think of, let's say, so this CCI decision looks at all of these digital services which JIO gives, which is JIO 7, JIO TV, JIO News, JIO Chat, JIO Browser, JIO Cloud, JIO Games, and My JIO, and then JIO Chat, right? So essentially, why is it that they are recounting all of these? Because they are saying, well, if you compare and contrast, then essentially your WhatsApp and JIO Chat are probably, in the same relevant market, and there is an overlap here, right? And therefore, it would mean that, there is some kind of a horizontal overlap, and it could also mean that there is some kind of a competition which is right now existing between the two. Now let's go back. Let's actually pedal back a bit, because if you recall, in the first 15 minutes of this presentation, I had suggested that let's look at the standard of review which the Commission is employing over here. So you will see that the standard of review, if we are concerned about anti-competitive effects, right? So the standard of review here is, let's say, if we are looking at this idea of horizontal overlap, because they are competitors, so the standard of review would be that, will there be a lesser incentive to compete between the two entities after the transaction? Right? So that is the standard of review which the Commission is employing over here. And you can see why is it that, they need to delineate this idea related to whether the two entities have horizontal overlaps or not. Because they are concerned about, let's say, prior to the transaction, they were competing with each other. Now, after the transaction, will they have a similar incentive to continue to compete, or will there be a reduction in incentive? That's the question which the Commission would be concerned about, right? So at this stage, I'm just hoping that these things are clear, but I also want to take some questions. So if somebody can just tell me what these questions are, I can address them just very briefly, because then I'll move on to the next part of this presentation. Can somebody please read the question for me? Okay, since none of you are reading, I'll just read it myself because I'll go on mute. Okay, earlier CCI also raised concern over data processing. So do you think deal with concern in personal data protection well and privacy? Okay, India does not have personal data as of now. Facebook NGO have huge consumer base. What would be the... Okay, all right. So okay, so I've seen the questions quickly because I couldn't hear anybody, but so you see, so there are two questions on this data privacy bill and what is the impact. So the thing is, you see, so as all of you know, and I think one of you have pointed out, there is no particular data protection law right now, right? All of this is in the works, so we don't really know what is the final shape that the data protection law will take. And therefore, I suppose, that would be speculative in terms of looking at what is it that the Competition Commission is supposed to do once the data protection law comes about. So we don't necessarily need to be concerned about it, right? But one question here which arises from the horizontal overlap bit, and which the CCI decision also looks at, quite interestingly, by the way, is what is the relevant market over here, right? For instance, like how do we really look at consumer communication applications, right? For instance, if we are concerned about, let's say, Facebook as any kind of a digital economy player, where Facebook is able to have the attention of the people for a certain time period, right? And here is what I will actually ask some of you to participate actively. And I'll ask you to do something. And if you can be honest, it would be quite enjoyable exercise. So what is it that I'm asking of you? So many of you will have smartphones, right? So if you have a smartphone, I'll urge you to do an experiment just for the purposes of today's presentation and put it on the chat, the end result of that experiment, right? So if you have a smartphone, you should be able to go onto your battery, right? So if you go on your settings, you should be able to go onto your battery life, or how much of your battery was used, let's say by which particular application in last week or so, right? Or last 10 days or so, right? Now you can do this experiment with yourself, and maybe you can just put it on the chat as well. My question to you is this: essentially, if each one of you go onto your battery and ask yourself a question, which is, how much time do I spend on Facebook, right? Now, will that be in last 10 days? Will that be 1 hour, 10 hours, 40 hours, 60 hours? What will the answer be? I mean, of course, you may believe that you are spending only half an hour or 10 minutes or 15 minutes or so. But what are you, in fact, spending time on Facebook as? I mean, that could be a good experiment. It's not a thought experiment, so as to say. It's a practical live experiment. If some of you can be courageous, stick your neck out, try and be truthful, and just tell me on the chat here. So when you go on your, let's say, battery on your phone, smartphone, how much time does it indicate that you had spent in last 10 days on Facebook? Just on Facebook. I mean, of course, it can also include some other social media if you're not on Facebook. Maybe you can use Instagram, maybe if you are more Instagram kind of a person. But Instagram is also Facebook owned, incidentally. Or any of these other social media, if the Facebook and Instagram are not your poisons. So then, and if you can put on the chat, it would be interesting to see what is it that the number is generally looking like. So I don't see anybody putting in as any numbers yet. But if some of you are listening, I hope that you will put some numbers here. Okay, so there's some 43.2% is what one person says. I'll not take out names, essentially to maintain your privacy. Though I suppose, um, though I suppose even if you want your name to be taken in the public domain, let's say even if you are okay with it, I'm not going to take it. So I just want to see a certain sort of an idea in terms of numbers, right? So 43.2%. Is there anybody else who thinks that the number is, let's say, either too high or too low? Maybe you can put your thoughts as well on the chat. But if you don't think that number is too high or too low, then then somebody says 24.8%. So you can see some data is coming about, right? Which is, so I don't know whether you do this experiment with yourself, but if you don't, I'll urge you to do this. By the way, our own self views are that we spend very little time on social media, but if you start looking at data, and when you start looking at your battery, how much of battery you are utilizing on these platforms, you will see a lot of battery life is just spent on these social media platforms, right? Why did I ask you to do this experiment? Of course, I see that many of you didn't participate in it, which is fine, which is not a problem. My purpose is served, which is, you see, one of the things which Jadoo has argued, by the way, in this order, quite interestingly, they say, you should not look at just the communication platform as the relevant market. They say that in fact the relevant market is much broader, which is market for user attention, right? Now, because you see, there are several things which are competing for our attention during the daytime, right? Which is, it could be that, instead of being on Facebook or Instagram, maybe we will do something else, maybe we'll be on WhatsApp, or we will share some jokes on WhatsApp, or maybe not, maybe we'll watch some Netflix or maybe any other competing OTT platform. But you see, what is the new economy essentially, right? The new economy is that all of these entities are competing for our attention, right? And this is what has been submitted by Jadoo, incidentally. Quite interestingly, they say that no, there is a much broader market, which is a market for user attention. And therefore, you see, they are suggesting that at the moment you look at market for user attention, then you shouldn't just be looking at a competition between, for instance, WhatsApp and GeoChat, right? You should be looking at a much broader set of entities. Now, this is something which is very common in competition law, right? How do you define market really, determines whether you are going to win a particular case, at least in the context of, let's say, abuse of dominant position, or maybe even in some context, let's say, merger control scenario, right? But here you will also notice that in the JIO transaction, what CCI ultimately says that because there are so many of these entities, we don't necessarily need to take a final view on the relevant market bit, and therefore it's not really much of a concern. So what do they really go ahead and do in terms of why is it that the commission is so comfortable with all of this? Because they say, look at these recent instances of other competing entities which have entered this particular market, right? They take some examples. For instance, so some of these, I have never used, by the way. So some of you might have used, but I have never used. But they say there are so many instances like House Party, Truecaller, then there is Snapchat, and Telegram. And I say all of these, they were downloaded during the COVID-19 times in unprecedented manner. This unprecedented manner. They don't give you the data, of course, they mask the data because they think that, it's a confidential information. But nevertheless, they are saying that, you see, there are so many competing entities, which means that there are really no barriers to entry over here. Which means the moment there are no barriers to entry or there is very little barrier to entry, it would mean to go back to our standard, which I had laid down right at the beginning, which is that, are there anti-competitive effects, right? The ACE. So you can see what is happening, that the commission is persuaded that because of very low barrier to entry, which is evidenced through entry of so many of these new entities, there is very little possibility of anti-competitive effects. And therefore, they shouldn't really worry about it. At least in the communication relevant market, this is what they think about. Now, there is one more relevant market over here, which we can deal with, which is advertising services, right? Unless, of course, there are any questions. So I don't see any questions on the chat, so we can move on. which is if you see advertising services, right? Now you see, I don't know what is your view of Facebook as an entity, but you can see how is it that Commission is looking at Facebook as an entity, right? So they are looking at Facebook as a platform where people can advertise. So they're looking at Facebook as a platform where a lot of advertisement happens, right? Again, to go back to the manner in which the relevant market was being delineated in the communication segment, that idea of market for eyeballs, right? How many people are viewing it, right? So you can see in a Facebook context, they're looking at, what is the advertisement which goes on over here. And there's some data which has been provided in the commission order. You can see this on page 12. So you'll see these data, which is table 1, advertising services in India. Then there is table 2, online advertising. Then there is table 3, which is online display advertising. Right? Now you see, one thing which is interesting is that the data here is all masked, right? Which is, they are redacted data. I'm of course deliberately using the term masked, which is, we are relatively more familiar with that term now, but these are redacted data, right? So you can see advertising services in India, what is the sales, what is market share percent, right? So these have been redacted as a data, right? Which means that these are confidential data which were provided. But after redacting all of these data, what the commission tells us that you see what is really happening is that this market on advertisement is fairly competitive. This is what they are saying, right? They're saying, in fact, if you look at the revenue numbers which JIO has submitted, it's quite minuscule. Again, the revenue numbers have been redacted, but you can go by what the commission has told us is that the revenue numbers are really minuscule. In fact, they give you a hint. They say that the revenue of JIO platforms from advertisement is insignificant and constitutes less than 1% of total revenue. Although, of course, for Facebook itself, revenue from advertisement could be quite large, right? So again, what are they doing? They're saying, on one hand, there's a very low barrier to entry. There are a lot of these new entities which have entered this market. On the other hand, they are saying if you look at the revenue numbers, at least from advertisement, looks like JIO has a minuscule sort of a figure in this particular context. And for others, although the data has been redacted, one can assume that there might not be a significant anti-competitive effect. So you see, again, seems like the commission is trying very hard to give us some sort of standard of what is the anti-competitive effect that they are looking at. How are they assessing this particular market, right? So far, I mean, it doesn't look like there is a major departure from what is the enactment asking them to do and what is the commission in fact utilizing, right? To go back to what I had said at the beginning of this talk, I had said there are two things I'll do. One is to look at it descriptively, what is it that the commission is doing, and then also to look at it normatively, which is whether the standard that they employ is that in accordance with the Competition Act or not, right? So far, it looks like, if we just confine ourselves to the descriptive limb of this particular conversation, it doesn't look like there is a major departure for the Competition Commission from what the Competition Act is asking us to do. So not a major departure, but nevertheless, let's see if there is any particular question in the chat. So there is one question. So let's see in the comment. Facebook and JIO are already considering to disrupt the financial sector. To what extent this deal would be beneficial in terms of financial inclusion of masses at grassroots level? Okay, now I'm not particularly sure what do you mean by disrupting the financial sector, but let's assume that they are going to disrupt any particular sector, not just financial sector. Wouldn't that be good for competition? That would possibly mean that there is a new entity which will come about in the financial inclusion domain. That could also possibly mean that for consumers who are going to utilize, let's say, the particular, let's say, services which Facebook and JIO might want to offer in the financial sector, that should mean that it would benefit the users, right? So if it is going to benefit the users, if the quality of competition is going to increase in the relevant market, so that should not really be an anti-competitive aspect of the transaction, right? So in that sense, looks like, what you're talking about in terms of financial exclusion as well, looks like a win-win for both the consumers as well as the entities, right? So it should not be a concern. It will definitely not be part of anti-competitive effects, the ACE standard that we have mentioned earlier. Right? Any other question? I don't see anything else in the chat, so I can assume there isn't any other. We have some time left for the purposes of going on to normative aspect. Of course, I'm keeping an eye on the time, so I've deliberately left some time. We are at 4:56. We have half an hour more, I think. So let's look at the normative aspect of the assessment of the commission. Is there something which we can say is which could be a concern from a normative competition act perspective, right? There is something else in the chat as well. Let me quickly see what is it. So Aniket Sachin says, will it be disrupting net neutrality as Facebook planning to deal with transaction-based revenue cost and may reduce other sites? Okay, so I think you had asked this question earlier as well, and I suppose we can deal with this question right now. What is net neutrality really? I mean, when technically speaking, net neutrality means that entities which provide internet services, right? Broadband, mobile, and all of these, right? Net neutrality technically means that every single user will have access to the same bandwidth, right? This is all theory, by the way, right? Because do you right now get a similar level or quality of services vis-a-vis anybody else? I mean, so of course, in theory, they all talk about net neutrality, right? Will they say, well, the moment you are a user in internet segment, then everybody must have equal access to speed and stuff like that. This goes back to, I suppose, earlier times when, there was a time when Facebook was thinking of offering, for instance, this face free basics, I think it was called, right? And therefore, at that time, there was a lot of furor that, is Facebook going to impinge upon net neutrality? But in some of these contexts, of course, these debates look very attractive, and I think a lot of people get taken in. But I mean, they are also just borrowed from the West, right? A net neutrality kind of aspect makes a lot of sense in US context where almost everybody has access to internet. People talk about net neutrality in India as well. I'm not very sure whether it means much in a context like India, only because to begin with, there is already a massive sort of difference between access to internet that people have. Even today, right? People who can afford access to broadband, they will have much better access to internet speed than others who can only afford mobile phones, right? So in that sense, if you're talking about just net neutrality in theory, so I'm not even sure how exactly Facebook and JIO will be able to have any impact upon this concept of net neutrality. If even in practice, I suppose you see, I mean, JIO can be seen as a player in this particular context because they will have through some entity or the other they have the JIO fiber and all of those offerings, right? But not Facebook, right? So in that sense, the target entity has an offering related to JIO fiber, but Facebook is not a player in terms of providing any broadband service. So in that sense, you can see already there is a lack of an overlap. So if we can go back to our standard earlier, which is it's not, I mean, they're in two different relevant markets, right? In which case it should mean that this idea of net neutrality should not be a concern insofar as this Facebook and JIO transaction is concerned, right? Okay, so unless you have a follow-up, because I think Aniket Sachin, so if you have any follow-up query over there, you can put up on the chat. But otherwise, we'll move on. What I'll do is look at the normative aspect here, right? What is the normative aspect? So what is it that the commission has ultimately done, though? They have said, and this goes back to what I had alluded to slightly indirectly earlier, right? Which is they asked parties, as a part of this transaction, are you going to share data with each other, right? And then they quote, they say that, and I have already alluded to this earlier, where they say, parties have submitted that, this is not the rationale behind the transaction. But what is it that is making the competition commission quite comfortable? Because see, you can look at para 53, sorry, para 53, page 24 of CCI order again. It says, in this regard, JADU, which is Facebook owned, has submitted that there is no data to be shared as part of the proposed transaction. Right? And then they quote it says it's further clarified in the response dated 12th of June 2020 that it is clarified that data sharing is not the purpose of the proposed commercial arrangement, nor will either side be acquiring ownership of others' data pursuant to the proposed commercial arrangement. However, for implementation of the proposed commercial arrangement, WhatsApp and JioMart, which is owned by RRL and operated by Jio platforms, will receive or send limited data. This data is being provided only for purposes of facilitating e-commerce. You will recall this, that this is the answer which I gave vis-a-vis the question related to master services agreement as well. So they are telling you some limited purpose for facilitating e-commerce transaction on JioMart. Its use is limited, proportionate, and solely for the purpose of implementing the proposed commercial arrangement. And then it says further, the MSA, which is the Master Services Agreement, explicitly prohibits the commercial arrangement partners from using confidential information received from the other party for their own business purposes or from disclosing it to third parties. Right? Now, this is the part which I suppose it does require us to look at this part of commission's analysis slightly normatively, right? Because you see, right after this, what really comforts the commission, they say in para 54 of the order, and I'll of course urge all of you to read if you have not already read. I deliberately use primary materials like the statute and case laws in order to do these kind of analysis, because I also want to emphasize that these are not my own thoughts. I'm just taking it from what is available in the public domain, right? So what the commission says in paragraph 54 is that any anti-competitive conduct resulting from any data sharing in the future could be taken up by the commission under section 3 and section 4. Now, how is it relevant for the purposes of our analysis? Because we are only looking at merger control, merger review, right? The moment you start talking about section 3 and section 4, it's very far away from merger review in the sense that you see, if you go back to our basics, which I had laid down right at the beginning of this particular discussion, first 15 minutes or so, that merger review is ex ante, right, before the transaction. Section 3 and section 4 of the Competition Act is very different because it's ex post. It's after the fact, after the transaction. So the transaction will be given effect to, it will be consummated, and then the commission is saying that trust us to look at their anti-competitive conduct, if at all there is an anti-competitive conduct, later on under section 3 and section 4, which is the enforcement or conduct related provisions of the Competition Act. What is section 3? What is section 4? Well, section 3 is about anti-competitive agreement. Section 4 is about abuse of dominant position. Is there any other instance where a commission, where Indian Competition Commission has taken action under, let's say, conduct or enforcement related section 3 or section 4, even though a transaction has been approved under merger control and merger review? Well, the answer is no, not yet. But here the commission is saying that, trust us, that, we have asked this question related to data sharing. They have told us that data sharing is not the rationale behind the transaction, but also trust us that, if we later on figure out that there is something going on about data sharing, which could be anti-competitive, then there is certainly these conduct related provisions, which is section 3 and section 4 of the Act. So in terms of my normative limb for the purposes of this particular interaction, I'm saying that, one can actually look at this slightly critically and think from the perspective of Competition Act, given that you see 10 years have passed, at least, or more than 10 years have passed for the commission, which has been engaged in conduct and enforcement related provisions now, right? Because these provisions came into effect from 20th of May 2009, so 11 years or so. Similarly, merger control from 1st of June 2011. So, around a decade or so of experience, right? Considering that, we haven't seen any particular, let's say, conduct or enforcement related action from the Competition Commission, at least in those transactions where merger control approval has been obtained by parties, how likely it is that commission will change the direction now and then possibly take a relook at this particular transaction. So it looks like, there is some gap in terms of the commission's analysis over here, at least normatively speaking, because it looks like, commission has left it for for later on, in the sense they have for themselves, I suppose, left a safety wall or escape wall, one can say. They have thought that there is a escape wall, which is that we can always revisit the transaction under section 3 and section 4. But considering that the escape wall has not been used until now, how credible this kind of analysis really is an open question. With that, we are at 5:06. I'll only say that in terms of my presentation, I'll go back to what I had said to you at the beginning, which is how should we look at this particular transaction between, let's say, JADU and JIO platform? Is it a magical transaction or is it a broom-based transaction? To go back, I had already told you why is it that I'm using these two terms as an allegory. I don't want to repeat for people who were part of this this particular session. I'm sure you understand why is it that I mentioned these two terms. But nevertheless, you see, when to go back to the anti-competitive analysis though, or anti-competitive effects analysis, if the transaction is magical, which is it going to be very effective, very efficient, it's certainly not a competition concern. Which would mean that if it is a very efficient transaction, which is based upon just, let's say, some kind of cooperation between the two parties, even if other competitors are not able to compete effectively, it should not be a problem. In fact, it's long-standing doctrine in antitrust law or competition law that the purpose of competition law is not to protect the competitors as such, but the purpose of competition law is to protect the process of competition, right? So if the purpose of competition law is not to protect competitors, right? So it doesn't matter that competitors are not able to live up to the heat which is rising in the kitchen, right? To go back to the Meru type of example, is Meru was not able to compete with, let's say, Uber or Ola. It's not a competition law concern. But at the same time, since the purpose of competition law is to ensure that the process of competition is somehow maintained, what is it that the commission is telling us normatively over here? The commission is telling us that there is a safety escape wall that they have left for themselves. That escape wall with section 3 and section 4, they are saying, insofar as anti-competitive agreement, insofar as abuse of dominant position provisions of Competition Act is concerned, they are telling us that rest assured that commission will not hesitate to initiate those provisions. But what does history tell us? I mean, last 11 years of history doesn't give us a lot of hope here, right? And therefore, I'm only mentioning to you, of course, this is not to assert that history is destiny, right? Because, it doesn't mean that merely because commission has until now not initiated any such investigation, there is a guarantee that it won't. That's not the argument which is being made. But, but this is what we do as lawyers, right? The life of a lawyer is what? We look at these cases. But all of these cases, in a manner of speaking, they are all historic, no? They have all already happened in the past. So in that sense, we are looking at the past, right? And then it's also inductive in the sense, we are just trying to look at one particular case and trying to see what will happen in the future. But then each of these cases are also supposed to be slightly futuristic. They are supposed to give us an indication in terms of what's likely to happen in the future, right? So in that sense, some kind of a deduction is also supposed to happen, no? Which is that based upon this past data, what is it that we can speculate? What is it that we can, as a prognosis, speak about the emerging jurisprudence of Indian competition law? So my assertion here is based upon jurisprudence, right? The jurisprudence of looking at case law, the jurisprudence of looking at precedents, and that is the kind of jurisprudence I'm trying to utilize, which is that, as lawyers, we of course look at precedents, which is supposed to be stare decisis, right? These precedents are supposed to bind. Of course, technically speaking, by the way, in a merger control context, because relevant market may differ, none of these commission decisions are supposed to function as a precedent or stare decisis, because each new merger control order will look at a new contour of a relevant market. So technically speaking, they are not supposed to function as stare decisis, but nevertheless, given that commission has here utilized the escape valve of section 3 and section 4, they are certainly suggesting that also look at our record in terms of what we have done in section 3 and section 4, right? So using that escape valve, I'm making a normative argument in this leg of my presentation that it doesn't look like the commission's escape valve or safety valve of relying upon section 3 and section 4, section 3 being anti-competitive agreement, Section 4 being abuse of dominant position, doesn't look like gives us a lot of hope and trust. So this is, what I wanted to suggest you to sum it up. I had started with this idea of, looking at this transaction from magic versus broom perspective, right? Again, to go back to that allegory, the idea was if it is a magical, very efficient transaction, no anti-competitive effects is expected. But if it is a broom whereby there are some, barriers to entry which are being created, there would be some concern on anti-competitive effect. But if we look at what Commission has done, it has possibly done some sort of a via media analysis, right? Neither magic nor broom. It's saying just trust us that if something goes on data sharing, we will not hesitate to employ our safety or escape valve of Section 3 and Section 4. In that sense, to use my title for the presentation, magic versus broom, it looks like the answer is somewhere in between via media, right? To look at neither magic nor broom, but to look at it from the perspective of Commission leaving for itself and escape valve. Right? So it's 5:11. I deliberately want to leave some time for some comments, thoughts, questions as well. So now we can go ahead. Astha,
Yes,
over
sir.
to
There
you.
is another question.
Okay.
Yes,
All
sir.
right. So I'm just looking
There
at
is
it.
another question from Aniket.
Sure. Sure.
Yes, there is another question from Aniket Sachan, and he's asking, earlier CCI also raised the concern over data processing. So, do you think this deal will be a concern in Personal Data Protection Bill 2019 or privacy as a fundamental right?
So I think I addressed this earlier. Since right now we don't have the enactment, so all of those debates are up in the air, right? Which is what kind of enactment we will have on privacy, or what kind of enactment we'll have on non-personal data, or what kind of enactment we'll have on personal data. So since right now we don't have the law, you will see that even for Competition Commission, they don't deal with the idea of personal data at all, right? Because since we don't have a particular enactment which can be enforced, it could be speculative. Okay? So give me a second here. I think I'm losing battery, so I'm going to just put it on charge. Okay. But go on. Is there? I think there was one more question which I can take from Annavaram. Just
Yes,
out of curiosity, what
yes,
other
sir.
business does JADU LLC has entered into after its induction in March 2020? And what are the main operational areas of JIO platform? So JADU, I think, has nothing else, right? Except what we have. So the order says that it's a newly incorporated entity. It doesn't have any other sort of business as such, right? So JADU, nothing else. I think in terms of JIO, I mean, you will see they are just expanding in a lot of stuff, from retail segment to so many other fields that we have. We will see in future months. You will see retail is one which certainly seems like a major interest, which has come out from the CCI order as well, right? But other things could be maybe, let's say, a platform business, right? So you would have seen in news items that JIO is thinking of, or it has already launched a Zoom type of platform, which can enable such kind of synchronous as well as asynchronous interaction between people like us who are sitting all over the country and interacting with each other. So those are the other business interests we'll have. But I would suppose that anything which is digital should be their area of interest, and quite legitimately so, right?
So I
Okay,
think
any
there
other
are no
questions?
more questions. Yes, I don't think there is another question. So, sir, thank you so much for joining us today. And you discussed some very important and very crucial issues related to Facebook Geo deal with the help of very real time examples, where you talked about some taxi examples and related examples. And you made this overall discussion very interactive and very insightful. So, it was really honored to host you today. And we all are looking forward to more session from you. Thank you so much, sir.
Thank you very much, Asta. Thank you very much for your kind words. And thank you for everybody who participated, put in questions. And thank you for those who did not put any questions but did participate, because they are equally important. Thank you very much.
Thank you so much,
Okay,
sir.
I'm going to leave the session. Okay, thank you.
Yes, sir.
Bye.
Thank you.